This video, I'm going to take a look at something that I come across very, very regularly, and that is the compromise agreement or settlement agreement, where an employee is going to leave the employment. So there may have been a dispute of some description, there may have been a grievance, there may have been perhaps even a disciplinary proceeding. The relationship as well may have just broken down between the employer and employee, and essentially they recognize, both parties, the employer and employee, that the relationship is broken down and they're going to go their separate ways. In these circumstances, you're going to have a compromise agreement or a settlement agreement. This is a negotiated exit which the employee is expected to sign. Now, in return for signing this, the employee is going to be given some sort of an exit package, a settlement payment, in addition to perhaps statutory redundancy and notice and any holiday pay that might be outstanding. The employee will also perhaps be given a settlement payment. In return for this, the employee will be waiving his or her rights to bring any claim against the company arising from the employment into the future. So if we just take a look at a compromise, a typical compromise agreement, and this is a kind of a standard compromise agreement that you will come across or may be faced with if you're an employee or indeed if you're an employer. So the first thing to note about the compromise agreement is that it's marked without prejudice and subject to contract. In other words, all aspects of the negotiation and all aspects of the agreement are without prejudice and subject to contract until there's a binding contract in place. That is, it's signed by both parties. At that stage then, you have a binding contract in place. Until then, there's no binding contract in place. Negotiations are on a without prejudice basis, and that means that if a concluded agreement is not arrived at, then the parties cannot later in a dispute, or if they go to court, or if they go to the Workplace Relations Commission, they cannot refer to what was discussed in the attempt to come to an agreement or a settlement. That's why it's marked without prejudice. So all bets are off until both parties are happy and both parties sign the agreement. Then you have a binding agreement in place. So your typical agreement is like the one I'm showing you on the screen there. Firstly, obviously, it's going to be dated. It's going to set out who the company or employer is and who the employee is. And then it's just going to go through some basic stuff like the employee is an employee of the company and holds the position of. And then it's been agreed between the parties that the employment will terminate on such and such a date in accordance with the terms of this agreement. Then it might go on to give some definitions. For example, if it was a very big company, there may be associated companies or group companies or something of that nature, but this is really technical stuff. It's not really too applicable to most situations where an employer is going to be terminating the employment of an employee on agreed basis. So as you can see there at number 2, you're going to have a termination date. So the employment will terminate on the termination date. And then number 3, the most important thing, well, one of the most important things, certainly from the employee's point of view, is the payment. So how much is the employee going to get by way of settlement payment or an ex gratia lump sum payment? One very, very important thing to recognize here is that there are very, very important tax implications to do with settlement agreements. So if you're an employee and you're getting a good package, or indeed even, whatever package you might be getting, you should be getting tax advice from a tax consultant, because the whole area of taxation surrounding settlement agreements can be quite complex. The only thing you can be absolutely sure of is that statutory redundancy is exempt from tax. Otherwise, it's possible that the payment referred to in your agreement is going to be a gross payment and will be subject to the normal deductions, for example, tax, PRSI, universal social charge, and so on. So make sure to get tax advice about that. Don't take your advice from a solicitor, and I wouldn't even recommend you take advice from an accountant. I would recommend that you get advice from a tax consultant. So that's the payment situation. That is absolutely key. The next thing then is most agreements will provide that the employer will pay some money towards the employee getting legal advice. This isn't just a generous altruistic thing on behalf of the employer. This gives the employer some cover, because the employee will never be able to turn around and say, I signed this agreement, but I want to bring a claim now, and I didn't know what I was signing. The employer will have proof that the employee has got legal advice, and the solicitor then will be requested to send an invoice to the employer to get paid. So the employer will have proof, and that will be the employer's sort of guarantee that whatever else might happen afterwards, the employee cannot turn around and say, I didn't know what I was signing and I hadn't got advice. So legal advice and legal costs, then it'll just set out there that generally the solicitor will send his or her invoice to the employer to be paid directly. The tax situation, then you'll see there in this particular one, the employer is deducting all relevant taxes, etc., etc. Sometimes these agreements will ask the employee to indemnify the employer against any taxation arising after the agreement. That is why it's crucial to get tax advice, particularly if there's a significant amount of money involved, and that's why you'll always see a statement like this one here. The employer will make the payments as tax efficiently as possible, compatible with law. That's all very well, but you really need to know, if you're doing a deal and you're an employee, you need to know what you're getting net, and you should probably, or you should certainly clarify that. This is very, very important as well. This is the waiver, so it's in full and final settlement. In other words, you as an employee are getting the money and you're signing away your rights. It's in full and final settlement of all and any grievances or claims that might arise from the employment situation. So you're providing a full employer waiver to the employer in respect of future claims. You're not going to bring any, you're absolutely hamstrung, and that's what the agreement is about. So you get the money and you don't bring any claims. That's really the deal, you know, and the employee gets an ex gratia payment or some sort of a termination payment, and the employer then gets the peace of mind and satisfaction that no claims are going to arise in the future. There may be a situation there where if the employee is getting expenses, that they're going to have to just settle up the expenses before they go. They're going to also undertake in the agreement to return company property, perhaps a laptop, perhaps an iPad, perhaps a company car. That all has to be done. Then there's going to be an obligation of secrecy on both parties. So the thing will be confidential. The agreement and the terms and conditions of the agreement will be absolutely confidential. There'll also be a standard sort of a clause there in relation to intellectual property. And there'll also be a clause perhaps in relation to communications into the future, that the employee is not holding himself or herself out as an employee of the company any further. There may also be, and it's something that you should negotiate if you're an employee, an agreed reference. So you should try to ensure that as part of any exit deal or exit package that you get, you're going to get obviously the payment, the termination payments, and you're going to get an agreed reference, and you should have some input into the reference and obviously get as good a reference as you can. An exit statement may be appropriate in some big companies. In other words, there's an agreed statement issued to the rest of the workforce as to, you know, you've gone off to join a Buddhist monastery, or you've gone to India to travel and find yourself, or something of that nature. But no, joking aside, it'll be that you've obviously decided to pursue other interests elsewhere or something of that nature. That may be an exit statement. In a small outfit, quite frankly, there won't be an exit statement, but you should negotiate an agreed reference. So you need to ensure you get the money, and you need to ensure you get a reference. Ongoing obligations, then both parties will acknowledge that they are bound by the terms of the agreement. And then the employee will be giving an undertaking in relation to future assistance to the employer. Again, confidentiality would be key, and then there'll be the few standard boilerplate things here, that this is the entire agreement between the parties and perhaps the jurisdiction, the governing law and jurisdiction of the agreement. One other thing would be that the parties will agree a non-disparagement clause. That is, both parties will agree not to badmouth the other party. So that's a non-disparagement clause. I don't see it here, but that would be standard enough. Again, it's without prejudice. So nothing is agreed until everything is agreed. The agreement is marked without prejudice until it's signed then by both parties. And at that point, it becomes binding and it becomes open, and that's it. There's a deal done, contract done, both parties sign. So there'll be two copies of the agreement. Basically, the employee will sign first, and then both goes back to the company, and the company will sign both and hold on to one. Each party then has a copy of the concluded agreement. Here's a schedule where you might have an agreed reference. So the company will set out in the agreement the reference that they're going to give when they're asked about your performance in the future, and They may also ask for a further waiver, even though the agreement itself is really a waiver by you, the employee, not to bring any claims against the employer. They may even ask for a specific letter of waiver to be signed on the termination date in addition. That's basically it. Exit package, settlement agreement, negotiated exit, parachute, call it what you like. It's a compromise agreement. It's negotiated between the parties. You do the best thing that you can do. You negotiate the best deal you can. If you're an employee, make sure that you get as much money as you can. Make sure you get tax advice and make sure you get a reference. And you do need to be absolutely aware, and you are to understand that you are giving up your rights to bring any claims afterwards. So whether it's personal injury or whether it's payment of wages or unfair dismissal or anything else, bullying, harassment, etc., you are waiving your rights. That's the whole purpose of it. I hope you find this video useful. If you do, you might give it a thumbs up down below. Thank you.